Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 76 of the NCDWI Guide podcast. On today's episode, this is like the big of all big guests coming on today's episode. I pumped him last week in terms of who we have on today, but we've got Chris Brooks in the house. He is the special deputy attorney general that deals with all of our mess that we create every day with clients when it comes to ignition interlock issues, limited driving privilege issues. When you have a situation that you can't get figured out, you do what I do. You send Chris an email. He is so good about getting back to you and very politely telling you in a nice way, like, here's where you made all of your mistakes. But he does it in such a kind and helpful and educational way. And Chris, it is just a huge blessing to have you on the podcast. To just go on for one more minute in terms of just touting you. I have been at several CLEs where you have taught and kind of helped us better understand what's going on behind the scenes at the DMV, how we can better practice at the DMV. And it is such a huge help to have that gap bridged by somebody that's, maybe to some extent sitting on the other side of the table, but you do such a good job of helping us do our job better. It's just an honor to have you on the podcast. So thank you so much for agreeing to do this.
I appreciate it. And I really appreciate the honor. I enjoy it. And we're all working together, sometimes on different sides, but working together for a final goal. And I enjoy doing this. The CLEs have been fun because you guys can understand what we're saying and we understand what you're saying, and it works out better. We all look better in front of the judge or judges or justices when we do it. So, but I appreciate it. It's an honor. Thank you so much.
Absolutely. We do. I mean, when everybody kind of has a better sense of what's going on at the DMV in terms of the hearings, it really changes the way that we can kind of move forward, how we can present things, and making sure that we're doing a good job for our clients at the end of the day. I mean, that's really what it's all about. So, in terms of, some of the things that I think you've really helpfully pointed out at a couple of the CLEs that you presented is really some of the most common mistakes. So I sometimes feel like when I'm sending you emails, man, I'm just blowing up Chris again. Apparently I'm not the only person doing that. I am not alone in kind of keeping Chris Brooks's email blown up. But in terms of the biggest issues that you see, let's go through a couple of different areas where you can kind of point out, here are the major things that I kind of routinely get questions about from defense attorneys. And so maybe to just kind of kick it off, limited driving privilege is obviously one thing that we're doing so often with a DWI case. So what are some of the practice points that you can point us in to kind of help our clients long-term with making sure we're getting those privileges filled out correctly?
To me, one of the biggest things we see is there's kind of error points that people miss. They might not think about it when they're applying for their limited privilege, but I picked out a couple of them that I see a lot. And one of the first ones is the person applies for the limited privilege and they pay the clerk $100, and the client messes up and thinks they paid the $100 for the civil revocation fee, the CVR, because they didn't pay for it originally. Right. And so the attorney goes through and gets the information, takes it up to the court, and then the court and the petitioner and the applicant get that nicety love letter from DMV saying, your limited privilege is invalid because the civil revocation, the CVR, hasn't been paid off. So one of the biggest things I think is making sure that the clients have paid off that civil revocation fee, the $100. And the fact is $100 for the limited privilege and $100 for the civil revocation kind of get confused sometimes, but DMV sends out numerous amounts of invalid limited privileges because of the CVR.
Yeah, to just maybe piggyback for one quick second on that point, because I think it's a really important point. Obviously you don't want to get that nastygram from the DMV that says that your privilege is invalid. Your client doesn't want to get that. A judge doesn't want to have this sent their direction. But particularly with the ignition interlock privileges, and again, I know we're going to kind of get into ignition interlock maybe in a couple of minutes, but that then is going to, kill the time that you're accumulating towards the ignition interlock. And so one thing that we do at the office that I think is just an easy way to avoid this is anytime that we are going to pay a ignition interlock privilege, we get the F1 screen printout from the court that basically shows that the civil revocation fee is paid. So basically, it's kind of like our internal check for making sure that $100 fee is paid, because I'll be honest, I mean, that's something that I have missed in the past. And, it is not a good conversation to have with a client. So again, this was kind of created as a CYA moment so that we could kind of fix this, but it's a really important point.
And the other thing is some people think, okay, well, I'll go and pay that CVR fee, the fee today, and they think the limited privilege gets put back in place. It doesn't. Right. That bell is wrong. The privilege is invalid. So you need to go ahead and get another limited privilege. And I know that's another $100 for the clerk, for the clerk's office and for the client to pay out. But that's something that needs to be done. And especially if you want to get that interlock time period running. I mean, I've had one last week where the person didn't pay the CVR. They went and paid it and they thought they were fine and they weren't. So it's really important to go do that. And the other thing I think is really important with some of those limited privileges, two other key points, is we battled this in court back and forth, and the Supreme Court went with a 2-2 unpublished opinion pretty much. But it's the under 21s, because a person gets convicted, they commit the offense when they're 20, and then it sits around for a couple of years and they get convicted later on and they're 24 or whatever age, and they think, well, they don't think about the offense date. So they apply for that limited privilege and, they're driving around and realize, oh, gracious, this limited privilege is invalid. So we work with AOC to see if we can get that privilege form updated. So one of the blocks on there says the person's not that age. But a lot of times you just don't think about it because it's been so many years since the person committed the offense. One of the other ones, too, that I see a lot is, you go print off the motor vehicle record and it says the perfect person has license at that point before the conviction. And then you don't realize that, 2 years ago when the offense happened, or a year ago when the offense happened, the person was suspended for something else. We see them, they're suspended for an FTA or they're suspended for some other minor offense. But when you go to pull that record and it looks good, you take it to the judge, and then you get the great letter from DMV saying it's invalid because at the time of the offense, the person wasn't licensed. Technically, shouldn't they get a DWLR or some other charge? Yes, but sometimes the officers may or may not charge that. But it's important to check the status of the license at the time the person committed the offense to make sure that that's a big one.
Just to those 2 points. So first of all, in terms of the underage person, to just make sure that we're kind of doing this the right way. Any person that is convicted of a DWI who at the time of the offense is less than 21, even if they don't get charged with or convicted of driving after consuming, if they're convicted of DWI, it would be the DMV's position that person is not eligible for a limited privilege. Is that correct?
Yes. And the reason why is some people go, well, you look at some of the statutes, but they don't realize that 2013.2 throws another suspension on there. And that's the one that gets them. It's been looked at several times by the legislature and the law hasn't changed. So if they're revoked for the DWI, they're also revoked for the provisional problem. So they're not eligible for a limited privilege. And we've had to litigate that a few times, but most of the time the judges have said they realize that they shouldn't be issuing that limited privilege, and they've changed it. And the key thing was getting AOC to change that limited privilege form. I think it might be box 8 or something on the first page, but just to let people know. So, but really they don't look back to 3 years or whenever it was that the offense occurred. And it wasn't intentional. It was just, no one thought about it then.
And so the other point that you just brought up in terms of the privileges. So at the time of the offense, if there is a kind of separate revocation at the time that the person is charged with a DWI, then that's going to cause an issue with the privilege then being valid as well.
Correct. Or if they weren't licensed, or they didn't have a valid license at that time period, that's going to cause a problem for them a lot of times.
Okay.
And one of the other things I've seen, it's not, it's just sometimes a miscommunication, is if the client is licensed in, let's say, Pennsylvania or some other state, they may full well be eligible for limited privilege, but when DMV gets it, it looks at the system. And if that out-of-state driver's license isn't listed on there, DMV doesn't know to go look at the other state. So therefore, they'll send out a letter saying it's revoked when technically the person was eligible, but they didn't know they had a privilege in the other state.
Right.
So making sure to make sure on the record to put the other state driver's license number so the DMV can check to make sure that that person was licensed at the time. Otherwise, DMV thinks, well, we run their name in the system, no license, because DMV's created a customer number when it gets the conviction because they're not licensed in North Carolina, so they don't know. And that can be corrected. Please let DMV know, let me know, and we'll try to see if we can get that updated. But DMV doesn't know, so it sends out the lovely letter.
Yeah, and I've had clients that at the time of the offense had either just recently moved to North Carolina or actually moved subsequent to the offense, reestablished residence in North Carolina, and so they're eligible otherwise for that limited driving privilege, but they never got a North Carolina driver's license prior to that. And that's definitely caused some questions for judges in the past. Why is this person that's from New Jersey asking for a limited privilege? And I'm like, well, Judge, they live here now. This is where, they've established residency. They've done everything that they needed to do to otherwise be eligible for the privilege. They got their DL 123. They've got, their work letter. They've got everything they need. Mm-hmm. And some judges just don't like the fact that's out of state, but there's nothing wrong as long as they're otherwise eligible with listing that driver's license number and out of other state license then.
Yeah, and a couple of other things that I thought about that I've seen a lot lately is misdemeanor speeding to a loop. And people try to apply for a limited privilege for that one, and they go, Chris, well, there's a limited privilege for the felony. You would think if there's a limited privilege for the felony, there'd be a limited privilege for the misdemeanor. Well, no, there's not a limited privilege for the misdemeanor. So that's this again. I'm glad I'm doing this. I'm learning as we go here, because that's something that I definitely did not have a good handle on. Not something that I see very much, but I actually have a case coming up in the near future that may change the strategy point on it. So. And people plead out thinking they're going to get the privilege, and then they realize later on, they don't get the privilege, so they've gone to file MARs and try to restart. But yeah, I understand the contrariness of it when you see that the felony hasn't, but the misdemeanor does. But that's something that's the way it goes right now. So,
and so what do you see? I guess from a visual standpoint, what does the DMV see then when that comes? I mean, do you see privileges that are filled out for felony fleeing to elude, but then you're basically in the system confirming that it was a conviction for a misdemeanor, and so basically this is the wrong form that is being used, and so we're kicking it back because there wasn't any conviction under the statute? How does that look from the DMV back end of things?
We see that conviction or that judgment being used, the limited privilege form, and we also see one of the ones that's others. A lot of times it's got the speedings and everything else on there. So DMV just, when it hits the system, it tries to key it on, and there's nothing for it to match up to. That there's a misdemeanor listed there, not the felony. So the code numbers will generate the letter that's sent to the individual. So it's the different forms. I've even had judges do a general form that they made it up themselves, or they didn't make it up, but the attorney or the applicant made it up and then presented to the judge, and they signed it. So I've seen different ways of doing it, but either way, if there's not a felony on there, the limited privilege is going to get is not going to be followed, and the notice will be sent.
Okay, yeah, that's great to know.
And one of the other ones I see a lot too, and people maybe disagree about some of the language, is limited privileges for speedings. And one of the things in that statute talks about if the person hasn't had a conviction in the last 12 months. The question has always been, what 12 months does DMV look at? Does it look at the offense date? Does it look at the conviction date? Does it look at the day that judge entered the limited privilege? And DMV's position has been they look at the conviction date. They look 12 months from that. And I understand some say, well, the conviction date was, close to it, but actually now the judge signed it, we're outside the 12 months, and so the person should be eligible. But DMV's position has been it's the conviction date. That's the date they look at. I get a lot of questions on that one, but that's their application of the 2016 point. I think it's 2016, one of those E11 or something like that. But that's what they look at it.
In terms of that, so in terms of the speeding from the date of offense for which you're trying to get the privilege, or I'm sorry, for the date of conviction for the offense that you're trying to get the privilege on, the look back period is a year to see if there's any other convictions, really for any traffic related offenses. Is that
correct?
Okay.
Yeah, that's exactly right. And the question has been what date you start with, and DMV goes from the conviction date.
On the speeding front, the speeding privilege has always been a little bit odd because unlike the limited privileges for DWIs or even for some of the other DWLR privileges, it's very kind of unrestricted in terms of like what it allows. Do you have any kind of like, practical points on that front in terms of, I think that there's an hour restriction on the speeding limited driving privilege, but beyond that, in terms of like purpose for which you're driving or anything else, is there any other type of restriction on that front?
Not really. Those are about as wide open as they get. Well, currently they're as wide open as they get. We'll talk a little bit later about the ignition interlock bill that's before the House and the Senate. That would change it to make the DWI interlock one the most widest range.
Okay.
Right now, has very limited restrictions on it. So it one's wide open.
Okay.
And one other thing I'd point out that some people don't realize, it's not in the printed book that I have sitting here beside me, but it is online, and that's changes to the FTA's failure to pay and failure to appear, and the failures to pay. I think in the court system they call them failures to comply. But right now there's a limited privilege for those. If you don't have any kind of other suspension in effect, you can get a limited privilege, because a lot of people are suspended for FTAs and FTCs. They haven't been able to pay their fines off, or they haven't appeared yet for court for whatever reason. That's the clients. But you can get a limited privilege for a year for those. And that's something that's new. And there are several bills in the legislature right now to make some tweaks to that. But making sure people know that they can get that limited privilege if it's just for the FTA or the FTP, and go ahead and start driving. And they would avoid so many DWLRs and different other NOL charges, but more DWLR charges if they went and got that limited privilege. Getting that will make them lawfully drive, and down the road, it makes it a lot easier for when they want to get their license back with DMV. That's a big one.
Yeah, that is helpful. Again, learning as we go here. I mean, I think that that's something I'm going to go back and take a second look at it. That's something that I haven't used a lot in the past. We've done a couple of the DWLR privileges, but in terms of the FTA, do you have the form number on that one?
I don't have the form number, but the statute is 20-24.1,
okay.
Subsection F, I believe. But
okay.
It's brand new. I mean, it's not the printed book, but it's one that's on the website, legislative website for the statutes. And I'm sure AOC's got a form for it, because it hasn't been out, but maybe about a year or so. It's a newer law. But there's at least 3 different bills that would tweak it a little bit more pending in the legislature right now. So we'll see.
Yeah, that's a huge help. I mean, anybody that's in that position, I mean, that the problem for people in that situation, and again, I always tell people from a legal perspective, if your license is revoked, you can't drive. Like, that's just you're not allowed to get on the road. But I know this guy's going to be going back and forth to work every day, like mentally, like there's, he's told me that, like, whatever it is going to be. And so it's kind of like, well, this is just going to snowball then. I mean, you're going to get charged with another driving with revoked license, and then another one. It's going to be permanently revoked for that. You're going to have to go to a hearing, and you're never going to be eligible for a hearing because you're going to get 5 more DWLR charges in the meantime. So, that's a huge kind of tactical advantage in terms of being able to get the, at least the limited privilege until you can kind of get the full license back in place. So,
and they started with some of that with the 2020.1 limited privilege for the DWLRs. That was kind of the instigator of some of this. If they're not revoked for a DWI or something else, let's get them back on the road. And this is another step that will eventually, it'll take out a large portion of the DWLRs, because a good number of them aren't for DWIs. They're for the FTAs. And
exactly.
Get rid of those. It'll help out a lot for the individual. So that'll be interesting to see. I think one of the biggest things that people, and I've said this in the CLE presentations, but I think the very, very biggest problem that I see is people not using the correct DWI limited privilege form. They go have their client install the interlock. They've got their proof of installation. They've got everything. They've got their 1, 2, 3s, and they go and they use the wrong form. They use a regular limited privilege form. And then their year is up, and that limited privilege is valid because, they were eligible for it, and the trial court is the determiner of the limited privilege, whether it's the interlock limited privilege or regular limited privilege. And when the year's up, they go to DMV and knock on the door, and DMV says you owe interlock for a year. and they're like, well, I had this privilege and I had this interlock installed. And DMV's position has been, and I've been to court several times for it, is, look, if you didn't have the interlock limited privilege, you don't get the credit. DMV is bound by the law. It says you only get the credit if you have the interlock limited privilege. And I feel sorry for the individuals having that interlock for, a year before, 10 and a half months before the time comes for restoration. But if you don't use the right form, you're not getting the credit now. So,
yeah, I would assume that a lot of the calls that you get, or emails, I know that most of mine are related to some sort of ignition interlock credit, right? Because, normally you're almost like past the point when the limited privilege was in place, or even if you're not, there's probably something that you could do to fix, basically go to a DA and say, my client got, charged with not having a privilege. We didn't realize that it had been submitted. The wrong form was, whatever it might be. The DA is probably going to take like a common sense approach to that and say, okay, well, now you've got the right form. He had the wrong one at the time, thought he was dry. Most DAs are going to take a common sense approach to that. But with the ignition interlock credit, you're talking about, money that is already been spent, is going to have to get spent again in the future. And so, that's a kind of mistake that a client is not going to be able to easily let go of. That's a big kind of contention point in terms of what's going to be that conversation over the phone or in office, whatever it might be. So I again, along that lines, I would assume that's kind of where you see most of these, as the wrong form is used, and then, the person doesn't get credit for the interlock. What would be, and I don't know if it's a good time to move on from any of the limited privilege questions. If it's not, certainly share anything else along those fronts. But in terms of the interlock, that obviously is like a big ticket item of how can we make sure that our clients are getting credit for the interlock, that they're, not causing any further damage financially for client having to get it put back on, even if it's for a week or whatever it might be, to get that full 365 or 3 years credit, whatever the case may be.
Yeah, that's check the form and check it again. And sometimes some of the administrative staff may put the form together, but at the end of the day, it's the attorney's responsibility. And that's something they need to at least check, not once, twice, sometimes 3 times, because we're talking not only having to have that interlock for now 10 and a half months, but also having to pay for it.
Yeah.
So I know that people don't love to have to blow and go, but that's their requirement. So check it, double check it. And that's one of the things I point out. If you learn anything from any of these conversations, just to make sure to check that privilege. Thereby, why does DMV do this? Well, DMV does not have a position in it, but DMV has to follow what the statutes put forth. It's not like they want your client to have the interlock for another year. It's just It's required. So I know as soon as DMV doesn't follow law, somebody will be raising Cain. So we need to make sure that DMV is a creature of statute and follow the laws that are in place. So it's a concern. Just make sure they have it. And the other question I get asked a lot of times is, well, I'm not sure if the judge is going to order ignition interlock or have a regular limited privilege, because it's a determination of the judge. And they say, well, at trial, there was no interlock introduced into evidence. So we could go with the regular limited privilege. And well, do we want to go ahead and get that clock started? So it's something that people want to think about. You show a copy of the BAC after the conviction, the judge sees a copy of the readings. Maybe you want to have that interlock limited privilege, because under the laws right now, you have to have that interlock in your car. And there's an exception for work vehicles. So you go ahead and get your time running. The courts regulate the interlock limited privilege. It's not something regulated by DMV as far as, making sure your readings are going and everything else. If you were to blow a certain thing every day, then that's for the court and for the DA to determine, not for DMV, because you have no DMV issued license. So it's something to think about. You can have it in one car, you can have a work exception, and DMV is not regulating the supervision of the interlock in the vehicle. Maybe you want to go ahead and get that time started. Because at the end of the day, when you come to DMV after your suspension's done and you've served your 10.5 months of the thing, you owe the state of North Carolina 45 days at a minimum. Well, when you come in, then you've got to have it installed in every car that's registered in your name. If you've got an ex-spouse in another state and that car is registered in your name, I'm sorry, but you got to have it in your car. And people get asked that question all the time. Chris, you got to be kidding me. And I'm like, No. And if your child's out in California going to school, if that car's in your name, you're going to have the interlock in there. And I understand that there's concerns with that, but that's how the law is written right now. We'll see if things change on it. And I think one of the biggest things dealing with the interlocks is Senate Bill 183. It's House Bill 402 that has come from the Governor's Highway Safety Program. They're the kind of the ones that helped work on that. And they were the Interlock Coalition was on there. The defense attorneys were on there, members from AOC, DOJ. A lot of people were on there. We came with this bill, proposed language that everybody liked. And I know it's proposed. It's not out there, hasn't been put into law yet. Hopefully the legislature will do it. But one of the biggest things with that bill is it gets rid of the 45-day lockout period.
That's a huge deal. I mean, that's a massive deal for most people.
And so that person can go get their limited privilege day one and go ahead and get their interlock time in, have their limited privilege. So at the end of the year, they don't owe any time with DMV as far as a license restriction. So they can go ahead and get their license back and be on the merry way. It's really important too, because it gets rid of that 45-day lockout. It also opens up the restrictions. They're not the restrictions, the time and location restrictions like you have on a regular limited privilege. That's huge. So this would be you have the most privilege with this limited privilege. I'm not saying I'm contradictory, but that's exactly what it is. It basically, you just have the interlock in there. And another key thing with that bill, which is huge, is it changes the alcohol concentration restriction for many DWIs from 0.00 to a 0.02. And people go, well, Chris, that's only 0.02. That's huge.
That is huge. Yeah.
Because people are arguing the mouth contaminants or this, that, or that problem, but it wasn't.
I would imagine that would take away about 80% of violation hearings. I mean, would that be kind of what would be the expectation on your front?
That it would take away a lot of them. And it would take a lot on two purposes. Number one, because the person has already served their year by the time they get to DMV, so they never have a DMV restricted license with interlock. So that would get rid of a lot of cases. And then two, the O2 would get rid of a lot of what people allege to be mouth contaminants. No, right. They may or may not be. I don't know. Only the client would know. But it would get rid of those, and those are a large percentage of those. That would help out everybody. The other big thing with this bill, and I'm not lobbying, I'm not acting like a lobbyist right now, but
you're doing a good job. I think from a defense attorney standpoint, we should do everything that we can to push this forward. This would be a bill that would really help clients. I think that there are so many people that are worried about how they're going to get their kids to school, how they're going to get to their job for that 45-day period. It's their first offense. They don't have anything in the past, and they're really struggling to figure out how they are going to make 35 days work, right? And again, I think most people want to comply with whatever is required from the court, from the DMV. Nobody is looking to go out and get a bunch of driving with revoked license charges, but there is a lot of planning required. I tell most clients that are facing that 45-day waiting period, this is going to be one of the biggest things that you're going to want to plan for. And we might move the court around just based on that one fact. It's like, there's no good time to lose your license for 45 days. But if there was a good time, when would that be? When would be like the ideal time to not be able to drive for 45 days? But if you reduce that down, to zero, like is the case with the standard limited privilege, that would really change some people's lives. I mean, it would really help.
Yeah, and two, when that year is up, when they come to DMV to get their license, they don't have to put it in all cars. They've served their year. So, not having your ex-spouse have to install an interlock in his or her car it saves a lot, and your kids not having to ride around that are in college or where else, or your 16-year-old having to have an interlock in their car because you own the vehicle. It's a big change. So that's something I think that hopefully that the House and the Senate will act on it, and hopefully the governor will. I don't know.
For any listeners out there, call your local representatives and just tell them what a good thing this would be for both the public safety, but also obviously for your individual clients. Again, I think there's multiple reasons that, there's support kind of across the board for this bill. But clearly on our end, number one kind of reason we'd be advocating is for the, individual clients that we represent. But this would be a hugely helpful thing for people that are otherwise good members of the community trying to, again, get back and forth to work, run errands, get their kids back and forth to school, that type of thing. So it'd be a huge help.
And how many bills do you see, the Conference of DAs or DAs and defense attorneys and AOC and DOJ, and all these groups coming together and agreeing, and DMV,
Yeah.
everybody is supporting it. I'm not sure if it in the coalition of ignition interlock providers. I haven't seen anybody that's contrary to this bill. So, it's a good bill. Hopefully it'll pass. Maybe there's things that I don't know about with the bill, but hopefully it would be efficient, I think, for the state as far as the drivers and your clients as well. So it's a good thing that helps out with the interlocks. And it would really change interlocks, especially with DMV, because all those 45 days individuals would be gone. So.
Yeah, that's a big change. Yeah, to jump back actually to one quick thing that you had said a couple of minutes back, when it comes to the difference in kind of a 0.15 alcohol concentration as found by the court versus the DMV. So there are certain situations where maybe the alcohol concentration does not get introduced in terms of the court end of things. There's still a conviction, but no special finding as to a 0.15 or higher alcohol concentration. When do you kind of see that the court doesn't, kind of find that special finding, but then the DMV still recognizes the 0.15? And what kind of results from that? Like where are the places that we can, again, advise our clients the right way on that front?
Well, the law changed. I think it was in 2006 with the DWI technical correction bill. And the law used to be that the court would find the BAC level for DMV purposes. I mean, the court always finds the BAC level for court purposes, but for DMV purposes. But with that technical corrections bill and the DWI bill in 06 and 07, it changed. And what it basically says now is the DMV shall rely on the affidavit revocation report. Whatever the court does with it, the DMV shall rely on that. So now we'll get convictions where, let's say, the analyst isn't there, or there's some suppression or something that happens. The BAC isn't found below, but DMV receives that affidavit revocation report. Well, in that situation, technically under the statute, the person is required to have the interlock at restoration. Now, there are some instances where a court will enter an order talking about, the method, how the test was done, or certain things that maybe the division will take off the interlock restriction. It's kind of a case-by-case analysis, but at the end of the day, the statute says DMV, if it gets an affidavit showing the 0.15 or higher, it's put on there. DMV's position in the past has been, if an order is entered that it could arguably bring up an issue of collateral estoppel or something like that, dealing with the merits, then DMV is going to take the restriction off. That's the current position. There have been times when DMV says, you know what, the order is not about the merits. It's a Melendez-Diaz or some kind of, foundational issue. So DMV has kept the restriction on there. We've been to court several times, and all the times that I've been to court on it, the courts have either dismissed the action or affirmed DMV's requiring the restriction. So it's something that it goes back and forth. But I think the main thing to remember of any of this is that limited privilege, if the judge issues that regular limited privilege, then that regular limited privilege, if the person is otherwise eligible, stays in place. If your client gets a letter from DMV saying the privilege is invalid because they didn't have an interlock restriction or they didn't wait the 45 days, please let DMV know or let me know. We'll make sure to get that updated, because the interlock restriction is something that for a limited privilege, the court does. If the court doesn't find it, the limited privilege is valid. And that may have not gotten processed right at DMV. So DMV needs to update to show that a valid limited privilege. Now, they won't get interlock credit, but they still have the valid limited privilege. But when it comes time for restoration, if DMV got that affidavit, in many cases, they're going to go ahead and require that interlock restriction. And that's the kind of question that I mentioned earlier is, do you want to start the time now or start it later? If the evidence isn't introduced at trial dealing with the BAC, then I don't think there's a requirement for the court to make an interlock restriction. But that doesn't mean your client might not want it.
Right.
So that's something for determining on the evidence what you want to decide.
Yeah, I think one place that I see this has come up a couple of times is where we have, canceled the blood, but whether it's based on a PBT or a hospital result that is clean, we know that the SBI lab result is going to come back high. So we kind of make the determination from a strategy point. Let's go ahead and enter the plea now, basically cancel the blood. but then the blood, instead of kind of getting canceled, ends up getting submitted to the clerk's office and submitted to DMV. So you go forward with the plea. Your client thinks that the blood is getting canceled. It still gets sent in to the DMV. So I think maybe just from a practical standpoint on that front, really try to follow up and see if you can make sure that blood is getting canceled, that the case has already been handled, whatever you need to do kind of paperwork wise, or kind of following up with the state to make sure that they cancel the blood. If that's kind of the reason for entering the plea at the time, that then it really makes a lot of sense to follow up on that front.
Yeah, it does. And we see a lot of those where they thought it was canceled, but the labs, either the crime lab or, the independent labs or the local county labs have sent it to DMV, and people are upset and like, well, we got it. We can't ignore it because by statute, they're required to send it to DMV. So checking up, make sure the DA send that paperwork and it's proceeded down that route. So
and it doesn't matter that it was received after the conviction, correct? I mean, it doesn't make any difference in terms of whether or not that restriction, interlock restriction applies. Okay.
Yeah, pretty much you're going to have a year by the time the person comes in for their license. So that time period the suspension is served, that there could be a year. So double checking, make sure that it was canceled, and get confirmation from the lab or the DA that it was done. Because otherwise, if DMV gets it, the court, all DMV cares about for the restriction was there a conviction as far as looking at the courts. Everything else is what's sent to them that they're relying on.
Gotcha. Okay. Yeah. In terms of anything else, interlock wise, privilege or what's happening once you kind of have license reinstated, what other hiccups do you see coming from kind of an interlock issue that causes problems with a client getting credit for that?
Well, one thing I want to make sure to point out too is this is something newer. DMV does, like, a person is conditionally restored or usually it comes into conditional restoration for people who have longer suspensions, permanents, or that 4 years. Is DMV has a contaminant review now. So basically, if they get a report in that says a 0 and then a 0-1 and then a 0-0 again on a retest, that looks like, and probably in 99.9% of the cases, is a mouth contaminant. It's not a violation. So DMV has a process now where it'll look at it, and basically, with people who are conditionally restored, they've notified as a part of their agreement that if we do this contaminant review, you need to pay this contaminant review fee, basically, because a lot of DMV hearings now, or just about all of it, and the personnel are fee funded. So there's an administrative code talking about this contaminant review, and DMV does it. People will get that notice about, okay, there was a contaminant review, here's a decision on it. I think right now it's $75, and they're not paying that $75.
Right.
And then they end up getting canceled for not paying the $75. So just remind them, if they get it, okay, you may not like it, and maybe it was a contaminant, but DMV is not holding a hearing, and DMV is not canceling you because it was a contaminant. Go ahead and pay it off. You've agreed to it in the agreement. Just do it. I know you don't like it, but just do it and stay up on that. We've got cases now where people didn't pay that $75. That they were permanent for DWIs, and now they're canceled for that. And I know they don't like it, but it's something that there's justification for it. And in the end of the day, they really like it because they've avoided the hearing,
right,
and the possible potential of being canceled for 4 years instead of canceled for 1. So it's really important to make sure to pay that fee. And the other thing I'd say about interlocks is if you're having an interlock hearing, DMV notices you for the ignition interlock violation, contact your provider and try to get a report. Look over the report. Realize what DMV may be looking at. They got this violation on this day. It's probably that. And if your client thinks that it's not alcohol related, take notes, know what's going on, because you come into a hearing prepared. And you've talked about this in your other podcasts you've done, being prepared for the hearing and knowing what's going on. And if they have, a document what was going on that day, that know the numbers and they can explain it, not, off the cuff trying to remember something that happened 8 months ago. It gives more credence to their story. Now, they didn't have credence before, but it gives more emphasis on, maybe it was a contaminant or something else. But try to be prepared. Contact your provider. They're supposed to be providing reports to them upon request. So go ahead and get those and be prepared. That's a big one, I think, with interlock hearings, and that includes conditional restoration people getting notice for them, and also the 17.8 violations where they've gotten a positive reading on an interlock device in their car.
Yeah, one of the things that I think is a little bit different, I guess, in terms of the interlock area. I mean, I guess they all have an effective date, but the ignition interlock privilege has a kind of an effective date. One of the ways that I've kind of used that in the past is that if I have somebody that gets the interlock installed and then doesn't get the privilege signed until a day or two later, court is closed or whatever it might be, I'll put the effective date in there as long as they're otherwise eligible. They've met their 45-day time frame for the date that they had the interlock installed. Do you see any kind of issues or kind of advantages of how to use that effective date? What if anything do you have in terms of that part of things?
Well, DMV has been relying on those dates that the court does. So, if the court puts it on a date, it's a day or two later or whatever, the DMV is going to rely on that because it looks at the privilege, it looks at the the text on the privilege, and they go with that. So, if the person is otherwise eligible, there's no other restrictions. So DMV is going to follow it by that effective date. So that's why that effective date is so important on there. So, I mean, not backdating something. I mean, when you start talking about backdating, we start talking about other situations. But when those kind of situations, they should be looking at the effective date.
And in terms of, I guess, when you have somebody that does have, like, let's say files the wrong privilege, is there any way of fixing that, or is there any way to kind of, I guess, continue then or go in and get credit? So you have somebody that, let's say, files the standard limited driving privilege. They should have filed the ignition interlock. You're 6 months into the 1-year suspension. You get the letter from DMV stating that this isn't the right privilege. What's the best way of fixing that at that point?
Honestly, I don't know if there's a way to fix it.
Okay.
And I said they rely on the effective date, but they also look at some of those other dates. And if they're trying to really backdate the limited privilege, it's not going to be accepted.
Okay.
Especially if the original privilege was the wrong one entered.
Gotcha.
It's not going to. DMV hasn't been giving them the credit. And the other key thing is, I've seen ones where the limited privilege, the suspension is ended, and then a judge wants to nunc pro tunc back to the original suspension. And DMV hasn't been following that either, because technically, once the suspension's ended, the person's not eligible for a limited privilege, and any limited privilege that the judge issues at that time period it's in default. Because default, I think of a better word maybe later, but
once the suspension for DWI is no longer effective, I mean, once you're kind of at that point that you're eligible for license to be reinstated, DMV's position would be that the judge really doesn't have any authority to issue limited privileges. Correct. Okay. Yeah. I mean, I think that is so in terms of, again, going back to that example of you're 6 months in, at the very least, you could apply for a ignition interlock privilege to start from that point moving forward. And DMV would honor those, final 6 months of that privilege time.
Absolutely. It's no different if the privilege isn't about it didn't exist. But if not, once it's corrected and it's on over there, make sure that it gets sent over to DMV so they can put that on, and they'll be getting that credit from that point forward. Absolutely.
Gotcha. Okay. Yeah. I guess in terms of other issues that you see, we had kind of talked about prior to the call, some conviction related issues. Tell me what you kind of see as being kind of repeat problem points on that side of things.
I have 5 different things that I usually see, and I'll name them real quickly and kind of go through them. The one is to check and see if your client had a CDL at the day of offense. That's a big one. The other one is acknowledgement forms. The other one is notice of appeals. One of them is FTAs and FTPs, and the other one is client notices. It's kind of a brief summary of them.
Okay, great.
But with the CDLs, I think it's really important that people look. They get the conviction, they try to do a PJC or something like that, and they realize that when the offense occurred, the person held a CDL. And they may have downgraded later on, but DMV's position has been, if you commit that offense while you hold a CDL, it's not going to be PJC.
Just to clarify, we're not talking only about DWIs.
Correct.
Okay.
Correct. It could be a speeding. It could be a lot. Well, you can't PJC any DWI, but with speedings is a big one. See a lot of those. They've had 4 other speedings or whatever else, and now they really want to PJC this one. If they had a CDL, it's not going to be PJC'd at all. And
it doesn't matter that they weren't driving a commercial vehicle at the time of the speeding. So if they hold a CDL and they're driving their personal vehicle, they get stopped for speeding, they go in and PJC, that DMV is not going to honor that PJC.
Correct. That
Okay.
disposition has been, and it's basically look at the offense date and what they held then and there. And a lot of it is for FMCSA, Federal Motor Carrier Safety Administration reasons, but they want to look at that and check and see it. And some people, the conviction was, the offense was 5 or 6 years ago, and they've had a regular privilege for so long, so they don't see it and they don't look back at the offense date, the license the person held at the offense date, and that's a big one. You don't think about it.
Yeah, you don't think about that. That's a big one.
And your client doesn't tell you. So many people like, Chris, I didn't know.
Yeah, that's a big one.
And so check that. The other one is acknowledgement forms, and there may be some issues with DMV doesn't have the most up-to-date computer system, and AOC is changing computer systems with stuff they have, and sometimes I'm not sure if the acknowledgement form, DL 53 or DL 47, depending on which agency you're asking what it is, the person goes in and physically surrenders their North Carolina license. So that suspension should start that day. The clerk doesn't enter it in, or maybe somehow it gets enters in but doesn't get conveyed to DMV. DMV sends your client a letter saying your suspension starts 10 days in the future. And they're like, wait a minute, I've already served 2 weeks. I want my time to start now. DMV doesn't know. And if I run the computer system and I'll look at the conviction, I'll see that there was no surrender. DMV needs to make sure they get it. If you have a problem where you see that date is out there, it's not to the original date, let us know, let DMV know so we can go ahead and get that acknowledgement date on there and get the person's suspension starting when they did an acknowledgement form.
Just a quick question on that front. So if you have somebody that goes in and is convicted of a DWI, they don't surrender their license that day, they basically have this letter that comes several days later. That's going to then further push out the time frame. So you basically are starting 10 days later, and you're kind of ultimately ending 10 days later. So May 1st, you're convicted. You get the letter stating May 14th the scheduled suspension is going to begin. You're suspended until May 14th of the following year.
Correct.
Okay.
Yeah, it's that 10 days. And that's the notice. When a defense attorney is doing a DWLR charge, they want to see the notices that the person was advised that their license was revoked. So that's the notice that's out there. And it can be avoided, and if they do the acknowledgement form, and making sure DMV is aware of it. And if we get those a lot where there's some kind of issue between the courts and DMV. We don't know. It's not anybody intentionally doing stuff, but if we get it, we'll make sure that the record gets updated with that acknowledgement form.
Okay.
And I'd also point out too that if your client has no license and you do the acknowledgement form, you're not getting credit. The credit will come with the actual date that DMV sends in the letter. So you got to physically surrender your North Carolina license to get that time started upon the acknowledgement date.
Gotcha. Okay.
That's a big one. One of the things I've seen recently too is notice of appeals. Your client gets convicted, and then they want to enter notice of appeal up to district court, or Superior Court, or they want to enter notice of appeal up to the Court of Appeals. A lot of times when the notice of appeal is done in court right then and there, the clerk will note it on the system, and therefore that conviction doesn't get sent to DMV. But what I have seen is so that's really not usually a problem. But what we have seen is if a day too later, or later in the afternoon, or 9 days later, the attorney or the petitioner, the driver, files notice of appeal, then the clerk puts it in the systems. But a lot of times that information, as far as the conviction being appealed, is not sent to DMV. DMV doesn't know; it never gets it. So your client will have served that year, and then a year later they go ahead and we want to remand this back or get convicted in Superior Court. Well, DMV gets another conviction sent back, so your client's going to get another year put on top of that. And the question would be, well, could my client get credit for the first year? Well, technically it can't, because once DMV gets that notice of appeal, that first suspension is removed. It's no longer on the system. So if you do enter notice of appeal on a case, if you don't do it at the time of the conviction or the judgment's entered, make sure that is entered on the system, and the clerk's office sends that to DMV, or contact DMV. I know it's sometimes difficult with the move and COVID, get a hold of somebody at DMV, but check to make sure that suspension is off, because you've advised your client that the suspension is off. But then they're driving around Saturday morning or Saturday night with friends in the car and get pulled over and get arrested, and they want to know what's going on. They're going to call you and complain. So the thing is to make sure that DMV gets it so we can update the system to make sure that suspension is removed. That's a big thing.
On that front, in terms of the appeal, once the appeal is filed, again, maybe it's helpful to follow up or run a driving record several days later to make sure that it actually is not showing on a driving record. But yes. Is it kind of appropriate legal advice that you tell your client once we file this appeal, the suspension that was entered in district court is like immediately lifted? That's what I tell clients. Is that the right way to convey that?
Yeah, I mean, under 2016, any appeal, the suspension is lifted. So the question has been not whether it's lifted, is whether DMV got the notice.
Knows about it, right? Okay, gotcha.
So
okay,
it's really important to get that. I mean, once DMV gets it, they can take it off, and your client's fine.
Okay.
Kind of tied to that too is, and I've seen this in the past year a couple times, is your client goes in and pleads out to 10 different convictions. Let's say, I've seen it with a misdemeanor death and a DWI, and then felony speeding to elude, and they enter all these convictions, and different judgments get entered in. But somehow either DMV, the clerk doesn't send it, or DMV doesn't get it. I'm not putting blame on either side, but DMV doesn't get the conviction. So your client will serve a year for the misdemeanor death, and then 2 years later, DMV gets, or a year later, DMV gets the aggravating the felony speeding to elude or what other charge. Well, DMV is going to notice that conviction for suspension now. And the people always argue, well, Chris, we've already served the suspension back here. And DMV's position is, no, you haven't, because we didn't get it. So my point of my story is your client should be getting different notice letters for the revocations, making sure that they get those, checking the motor vehicle record, just like you do with the appeals, to make sure all of them are on there. Because it could be a ministerial error on somebody's part, but the conviction didn't get put on there. The suspension has not been on there. There are some times when DMV can give credit, but when you have the shorter one comes first, and the longer one comes later, and you wanted them to run together, and now they don't. So that's a concern out there. So anyhow, making sure that DMV gets the notices and the client's record has been run to make sure they're all on there is huge. We've had to do that out a few times.
Yeah, and again, I not to kind of pigeonhole you into saying this is how you're going to do this every time, but if you had a situation like that come up where you had two suspensions that really were supposed to start at the same time, conviction, they one of them gets entered and then the next one gets entered sometime down the road, what is kind of the appropriate process of trying to kind of get that figured out? Like, is that something that is a clerk-based thing, contacting you or somebody else at the DMV? If you're trying to kind of make that, I guess, argument, if you will, my client believed that this started at the same time, where is the appropriate kind of like remedy point on that front?
I think the first thing is to make sure the clerk has sent it over to DMV and updated the DMV system.
Okay.
And honestly, each case has to be looked at to see whether DMV could kind of run those suspensions concurrent or not. Sometimes we've had examples where it was a DWI DMV got and didn't get the misdemeanor speeding to elude.
Right.
Well, that person had the limited privilege for the DWI, and they wouldn't have had that limited privilege had the misdemeanor eluding been there. So,
okay, that makes sense. Yeah.
Each case is different, and whether the license is surrendered, whether they've been issued a license again, or just each of them we have to look at. But I know people don't like to hear it, but DMV's got to enter the suspension based on the convictions it's received. But maybe there's times that we can give credit to trying to run them together, but it really depends on each and every case.
Yeah, that makes sense.
Another thing I see too a lot is making sure that the FTAs and failures to appear and failures to pay, FTC as the clerks call them, making sure those are complied out, because you as the attorney may have got it complied out, may have gotten the court to send an error, or it's been struck, or it's been complied with, but some reason there may be a technology issue going back and forth between A and B. The DMV doesn't get that. Now they do most of the time. The vast majority of time, 90s or 99%, I don't know, but it seems like your client's going to be that 1% person.
That's right.
It's just making sure that has been conveyed over, because Sometimes it's not, and hopefully with new softwares and new technology, it will. But
it does seem like that has improved. The speed of that getting conveyed. I know, and I don't know if this is statewide for every clerk's office, but from when I first started practicing to the last few years, it seems like anytime that I've had to get like a strike order on an FTA signed at the clerk's office, it's almost immediately in the DMV system. So I don't know if that's due to, kind of statewide software updates or if that's more county by county, but definitely seems that those kind of issues or having to refile the same FTA order at the clerk's office have been kind of drastically reduced.
And I'm glad to hear that. But we sometimes they'll put in the North Carolina driver's license number, and the numbers are imposed, or you have this time it's Chris Brooks, this time it's Christopher Brooks, and then the records don't get synced up. So that's just something to make sure of it. Especially have a lot of them, because that client gets pulled over to checkpoints 6 months later and they're raising Cain. So it's just something to check, and hopefully it doesn't happen, but just realistically it happens. And when DMV gets it, it'll strike it, and it gets struck out to the original day. So it's going off the system, but that doesn't make your client any happier.
No, it doesn't. No.
Whatever else. So we want to make sure that happens. And so many times people are not happy with DMV, but DMV is acting on the information that they received. They're a custodian of records. So when they get it, they'll update it the best they can. So just making sure that you mentioned earlier about checking the motor vehicle records. It's very, very important. So, those are my 5. I think, I covered all 5 things of the convictions. But again, checking the records to make sure on there is a huge thing. It really is. And hopefully your client won't have to call you back unless to say just thank you and you're a great person. But it's something you may want to check.
Yeah, no, I mean, I think that those are always, kind of the most, kind of disturbing calls to get, because again, from everybody's perspective, we thought that we had dealt with this, but you're kind of immediately put on the defensive because, from the client's vantage point, this is what they hired you to do, is to make sure that everything is cleared up and, working appropriately and done right. And so, when they get pulled over down the road and, whether it's been some sort of an issue with DMV getting the information, or it's been some sort of an issue with it being entered, again, it's your fault. Like, I mean, and I would say somewhat
everything is your fault.
Somewhat legitimately so, because it's kind of like you should have got that, figured out before. But again, I know that for me, that's happened in the past. And again, regardless of why it didn't get entered in, doesn't really make any difference when you're in handcuffs in the back of a police car. So, but I think those are helpful points for us, I think, to take away in terms of kind of different things for us to be on the lookout for in terms of these new changes to the law. Again, you kind of went through the bill that's pending right now in terms of ignition interlock. Are there any other kind of pending legislation to be aware of currently?
Yeah, there's a big one, and it's House Bill 650. And at the end of that 10 or 11 page bill, you'll see that they changed the notices DMV sends out. So right now, if your client gets, arrested for DWI, and, they refuse, DMV sends them out the notice, they've got 10 days to respond. Under House Bill 650, which was signed last month, I believe, it's now 30 days. And that's something that's a big change from 10 to 30.
Huge difference.
It really is. We get a lot of people who say, I never got my mail, or I didn't check my mail, or the mail goes to my parents because I'm in college here.
This is literally every phone call for me in terms of the DMV letters. There's no, almost never a time when that's not at issue. So I think that's helpful.
And the 30 days is good. It gives you time more to converse with your client to see whether you want to appeal this or not to appeal this, and not just doing it really quick and then, withdrawing at a later time. So it's good for everybody. And that's for the refusal hearings. It's for the alcohol concentration restriction, the interlock hearings. I believe it's for all the big ones that DMV has. So that's a big change. That's in law. There is one I thought was interesting. It's House Bill 692, which makes the car lifts. If you have the front of your car jacked up more than 4 inches, it's now against the law. So that was signed in the last month. And the reason why that's important is because I think it's your third go around on that one, your license is going to get revoked.
Okay.
So it's now under 20-17. So it's a big one. So the 20-17 adds on the car lift. So that's under House Bill 692.
Okay. And that one is pending or passed at this point?
That one's passed. It's
okay.
been signed into law. I think it was in the last week or two. So it's a new one out there. So if I see a lot of kids driving around with their pickup trucks, and they can't see over the front of the car, so they have a camera on the front of their car and a camera.
Chris, I know you're driving around that lift. You're going to have to go into the body shop and get your car all rearranged just so that you don't lose that.
Jack it up the other way now. But I didn't even realize that when I saw it come out, and I was like, wow, I didn't realize that one. But the big deal is it's a revocation.
Yeah, that is a big deal.
So people don't know on that one, they see they look at the first part of the bill and they see it's all about, the car inspections and the car sizes and everything else. And 4 inches off the ground from both sides. And then you realize, wow, wait a minute, this is a revocation. And attorneys need to know about it if they don't. Maybe they already know about it, but I did. So the other would just be that House bill, the ignition interlock modernization bill. That's a big one. There have been some other DMV bills about vehicle registrations and stuff like that, but for the driving purposes, those are the big ones. And I did want to say, I was watching one of your prior podcasts about the hearings, and I just want to point out it's something that I would really want to stress. And reading the transcripts, I know the transcripts are cold, but sometimes you can tell when a person is not being honest and showing humility. You're going to DMV, it's a hearing. They're not a judge, but you make sure your clients treat them as a judge, and be honest and be humble and, just explain it. And I've seen cases where the person may be telling the truth, but the way it's coming across, it doesn't look like the truth. And, if you're there for an hour and they don't believe you in an hour, it's not going to look good for your client. So
it's not
being honest and humble. And, you'd also mentioned being prepared. It really helps your hearing when you come in, you've got your stuff. The attorneys are arguing cases and they bring a copy of the case to the hearing officer. Those are really big things in bringing the exhibit. So, hearing officers are people too. And they're going to treat people like they get treated. But, being humble and being respectful is huge. And unfortunately, I've seen it where people are not, and they're not being forthright and honest with the hearing officer. So it's not a big surprise that they didn't get the relief they requested as far as a conditional restoration. So just remember that.
Yeah, I agree. And I think, it's easy to chalk that up. I would say, in a restoration hearing, maybe in particular, but even in an ignition interlock or whatever the case may be, you have somebody that comes in and is like, I've served my time, my license needs to get back. And you could say, well, the hearing officer doesn't side with you because they're just being a jerk, they're interpreting this as just, you being a jerk, and they respond kind of, but I honestly think it's one of those situations where the whole purpose of the restoration hearing, or at least my vantage point that I think is a good thing for the client, is to realize I got to be like walking on eggshells for the time that I have my ignition interlock device on. I need to kind of make sure that I never again have to deal with this situation. So, maintaining sobriety, getting my ignition interlock, just making sure that I'm able to provide for my family. So I think that, the best way to see whether a person is ready for that moment or not is how they treat the hearing officer and how how they come in and communicate. I've learned that driving is a privilege and not a right. And when you come in demanding stuff, it's like you just didn't learn your lesson yet. This is something that, we're going to end up with more problems down the road if this is kind of how you are, treating this 4-year suspension that you just dealt with. So again, I really don't think it's as much when my clients this is especially true when somebody's called me about the restoration hearing that they just went through unrepresented, and they're talking about the things that they said. And I'm like, well, I'm not shocked that this did not go your way. This is not, a particularly surprising outcome. But again, I think from their vantage point, it's like I was treated unfairly. And, again, I think that really most hearing officers, I've probably been in front of between about 5 and 7 hearing officers in practice, and everybody, again, they're human beings. I think that one of the main purposes of this kind of character hearing is, do you understand the risk that you put other people in? Do you understand the value that your license conveys to your family, to your community. And so again, if you're going in there with this demanding tone, it's like, again, you didn't learn the lesson yet. So I wholeheartedly agree on that front. I mean, that kind of polite and respectful tone, it's not to kind of earn some sort of weird brownie points. It's more importantly to show that you kind of are taking this process serious, that you understand how important it is to have a driving privilege in the future. So yeah, I'll just re-echo that. I think in the future, it would be fun, Chris, to have you back on and maybe answering some attorney questions. I don't know if we could get like some sort of a live feed going, or if I can collect questions in the future and have them thrown your way. But again, I just so appreciate the openness that you've had with the defense bar, both in one-on-one contact through email, in the CLE presentations that you've done, just kind of, again, letting us see behind the curtain, which is always, again, I think much disruption or kind of this adversarial process has really, I think, been broken down by your openness about what the DMV's position is, how we're interpreting cases or statutes that are coming through. I think a lot of that is broken down by the openness that you brought to the conversation. So I just really, again, appreciate that. Thank you so much for coming on. And I hope it's not the last time. I'm looking forward to future conversations.
Anybody that knows me know I'll talk your ear off. So I appreciate it. And I've been fortunate. The AG here has let us work on things like this. I mean, I'm not speaking for the AG, but I've been working for the AGs for a long time. And I just appreciate the opportunity. And really, it's like I said earlier, we're working together. We may not disagree. We may sit on opposite tables, but at the end of the day, we can walk out afterwards and go grab lunch, because but the key is to understand the law and our positions. And I've found in the past that working together is a lot easier for all of us.
I love that. Well, I appreciate it very much, and look forward to having you again on in the future.
Thank you so much. I appreciate it. Look forward to it too. Take care. Thank you.
If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.